Hi everyone, I'm Laura.
And I'm Eva, and we are both family mediators who work as a team helping families through the process of divorce and separation.
I have a background in mental health and a master's of laws in dispute resolution.
And I'm a family lawyer, and we incorporate these additional backgrounds into the style of mediation we practice, which is called co-mediation.
This podcast is called Love, Divorce, and Everything in Between. And this particular video shorts editions will be focusing on divorce and separation. It is our hope to educate and guide you by sharing some of our knowledge and experiences as professionals with you.
We begin each episode with a review of a separation and divorce-related topic and why it may be important, followed by a discussion as it relates to our work experience.
And we'll do our best to answer all of your questions. So feel free to leave your questions in the comment sections below, and we'll make sure to answer them in our upcoming questions and answer episode.
Speaking of upcoming episodes, if you like this one, please hit the subscribe button below and turn on notifications so you don't miss out. In today's episode, we are discussing the differences between mediation and litigation. So this is one of our probably favorite topics because truly the mediation process and the litigation process could not be more different. So maybe let me start off with what is litigation. So litigation refers to the court process. Some families in Ontario go to court for their separation and divorce. In court, a judge is the person who is making the decisions on your behalf. So your parenting schedule, your child support, spousal support, property division, all of that. Mediation is completely different. Laura, do you want to maybe chat a little bit about that process?
Would love to. Mediation, in contrast to litigation, is a voluntary process. And both parties in a separation or divorce contribute together, co-author their final decision and their final agreement. So as opposed to court, where a judge will make the decision for you, in mediation, you get to make the decision for your family on your own.
Mm-hmm. And so it's probably best if we highlight the major differences between the two processes so you really get a sense of each process together. And so one of them is cost. So cost, time, privacy, another one, and then like Laura talked about, the control over the resolution. And so maybe we can just elaborate on that a bit. So just like Laura said it perfectly, in mediation, nothing can happen without your consent. Both parties have to agree on everything. It's essentially a negotiation between two parties with mediator or co-mediators like Laura and I, who are there to help the negotiation process by adding information, making it safe, and keeping it productive. In court, you don't have that. Both parties submit what they think should happen or how they think the judge should decide, and then the judge decides, and then the judge goes home and lives their life, right? So the control aspect of both processes is different. Something that Laura and I say often is that should be a motivator for a lot of families to try to settle out of court, because you know your family the best, and you know what your family needs the best instead of a third party. Right? And so if you can control the outcome and create what is right for your family, then why not do it in the mediation forum?
Another important difference is cost.
Mm-hmm.
Is between mediation and litigation, there is almost no comparison when it comes to cost associated with each process. Our statistics generally are showing that going to court, settling your matters through that route can cost families at least $24,000 to $50,000, and that's without even getting to trial. Mm-hmm. So the trial is a different ball game and huge costs associated with it. So that's in addition of tens of thousands of dollars. Whereas in mediation, generally, families can finalize all of their agreements for, in our experience anyway, for under $5,000 combined. So you can see how how cost saving it is. And why for me particularly is very important, and I know for Eva as well, is we know that families have worked really hard for their money, and fighting is only going to cost you. It's not going to make you richer. You're not going to gain anything out of it, and you're only just depleting your finite resources. So cost is a very, very big, important difference.
Right. We say to families all the time, instead of lining the pockets of other professionals, keep that money for your kids. Put what you would spend in going to court in an RESP. Right. Or take your family on vacation, or maybe you can continue the pro hockey or, dance lessons. The costs are astronomical when going to court. And so that's something you definitely have to consider, because it is unaffordable for the majority of families today in Ontario. Another big difference between the two processes are time. And so often in mediation, the resolution can happen within weeks. In our practice, I find that most families need about 6 hours at the mediation table on average, and they can stretch that over 2 or 3 weeks or over 1 or 2 months, but rarely do we have families going over 2 or 3 weeks. And that is a stark contrast to the court system. So Laura, I know you've looked into this. What is the average a family takes in the court system?
The average of families' time spent in the court system is about 22 months to get to some form of a settlement. And if you want to learn more about the court process, just check out one of our videos that is dedicated just to that topic. Needless to say, there are so many steps in a court proceeding that 22 months is actually the average. It can be a lot longer generally than 22 months.
That's absolutely right. And then, so we've talked about time, we've talked about cost, we've talked about control, but another really important aspect and difference is privacy. And so many families don't know this, but the court process is a completely open process. Unless we're talking about forms of child abuse, then which those cases are typically closed. But the majority of family separation and divorce cases are open to the public, which means, first of all, anybody can come in and sit in on a discussion of your personal family matters. And I've been in court before when there were field trips for students, elementary, high school, and even college students coming in. And so certainly, if you have private matters, right, you have to keep in mind that the courtroom can be open to anyone, and also transcripts are public. So anything that is discussed can be made public for anybody to look up.
In today's day and age, where privacy is almost non-existent, and it's such a fragile topic, in this particular forum, in mediation, you could actually protect your privacy and protect the most intimate details of your relationship, of your financial portfolios, all of that stuff. Just imagine if they become public record. To what Eva said earlier, it is also online. So it is online, it could be online public record. And it is, you're not the only one who gets to experience it at that point or reads it. There are now multiple other people who can read the most intimate details of your life and of your separation, which I think it is important for you to know, because you can make a decision on protecting that.
That's right. In the mediation process, what's important to keep in mind is everything is confidential. And not only is it confidential because there may be sensitive matters, but because we want to create an environment where you and your co-parent or your ex-spouse can come up with ideas for resolution. And those ideas would not be used against you in another forum. So the atmosphere in mediation is much more open, in the hopes that we can encourage an early resolution. And when we talk about the time differences, we see that quite starkly. That's why a lot of families are able to resolve things within weeks as opposed to months, because the environment is so conducive to encouraging the parties to resolve things right away.
Another difference that I find lots of people don't know until we inform them is education.
Mm-hmm.
Mediation is not just a negotiation process, but it's also an informational heavy process. So in mediation, you both parties get legal and co-parenting information in a neutral way, in a safe environment. As opposed to litigation, you will each get only legal advice, and it will be always formulated in a way to win against your co-parent of your children. So you see the huge difference there. You have information at the table in mediation that you can use to create whatever makes sense for your family. And in litigation, you are very limited, and the information is generally presented in an attacking way and opposing way. So that is another difference that you need to keep in mind when you engage in a process.
I'm Eva.
I'm Laura. And our ultimate goal is to make you aware of all your options regarding separation and divorce. So please make sure to subscribe to our videos for our future topics. And if you have any questions, feel free to leave them in the comments below, and we'll make sure to answer them in our future episodes. Bye.